Okay, we're going to get started. Unfortunately, I'm subbing for our great faculty director, David Wilkins, who couldn't be with us today. He's just been traveling and just got back into the country. But it is a special treat today to present to you one of our speakers who's a member of our family at the Center on the Legal Profession, Nick Robinson, who has spent 7 years in South Asia before joining the Center on the Legal Profession as a resident fellow. There he clerked for Chief Justice of the Indian Supreme Court, taught at the National Law School, Bangalore Jindal Global Law School, and Lahore University of Management Sciences, and was a senior fellow at the Center for Policy Research in New Delhi. He has written extensively about judicial process, the legal profession, and public law in South Asia. At the Center on the Legal Profession, his work focuses on the regulation of legal services, particularly comparatively. He has written on non-lawyer ownership of legal services, elite litigators at the Indian Supreme Court, and the legal education in India. His research interests also include occupational licensing and access to legal services. Nick has a BA from the University of Chicago and that other great law school in New Haven. We are delighted that he's here and he's going to present to you.
And just so you know, I do have a South Asia background. I'm not gonna talk about South Asia today, but if anyone's interested, I'm happy to talk at another time. Oh, do I have to turn this?
Yeah, just like that.
And it just works.
Great.
So today I'm going to talk about non-lawyer ownership of legal services and its impact on access. This is based on a paper that I wrote that's online. It's on SSRN if you want to take a look at it. And I'm just going to touch on some aspects of that paper. I'm not going to go through the whole paper. Just for a bit of a backdrop, as everyone in this room is aware, there's a huge access to civil legal services problem in the United States. The Legal Services Corporation did a study in 2009, which is the main mechanism by which the federal government funds legal aid in the United States. And they found that for in every program that they funded, for every client that they had, another client was turned away because of lack of money. And that's only clients who are coming to these programs. We know there's many people who need legal services who don't even reach out to lawyers, either because they don't know they need a lawyer or they don't have the money to access a lawyer. Traditionally, there's been three ways to think about addressing this problem. So legal aid, which has been stagnant or declining in real terms in the United States for the last several decades. Pro bono assistance, so free legal aid by members of the bar or by clinics at law schools like Harvard. But pro bono also has its own limitations in the sense that lawyers can only provide so much free legal aid, and they tend to only provide legal assistance for certain kinds of cases as well. The other strategy that's been put forward to think about how to increase access is regulatory changes. How can we change how lawyers are regulated to increase access, primarily by driving down the price of legal services so that poor and, importantly, middle-class people can also afford legal services in a way that they can't right now. One idea that's been put forward is to liberalize or loosen unauthorized practice of law restrictions, so to allow non-lawyers to perform some legal services. Another idea, which is a variant on this, is to create new categories of legal service providers. So the Washington State Paralegal Program is a good example of this, with the idea that a paralegal might be able to provide certain family law or immigration law services at a cheaper rate than a full 3-year JD attorney would be able to. There's been some traction on these, but both of these have largely been blocked by the bar in the United States. But there's a third idea that I'm going to talk about today, which has been gaining traction in the US, and there's been a lot of discussion about, which is non-lawyer ownership of legal services. So the idea here is the following, that it's still lawyers that are providing the legal service, but unlike a traditional law firm, they can split profits with non-lawyers. So this allows the ability to bring in outside capital and outside expertise, with the thought that this will create new efficiencies and drive down the price of legal services. So essentially, if we think Walmart can get you a television set at the cheapest price, why can't Walmart also get you legal services at the cheapest price? Now, for some in this room, this might sound like a foreign idea. For many others of you in this room, you know that two other major jurisdictions are trying this idea right now. So Australia has had non-lawyer ownership in most Australian states since the early 2000s. The UK and England and Wales specifically has had something that what they call alternative business structures since 2011, which is a form of non-lawyer ownership. And in the US, the American Bar Association has rejected the idea of non-lawyer ownership twice, primarily on concerns about how it might undercut professionalism and the values of the profession. But there's parallels here as well. So if we think about online legal services like LegalZoom, many of you know that LegalZoom has private equity that is invested into it. Binder and Binder, some of you might have come across. They advertise a lot on late night TV. They do Social Security disability representation. Social Security disability representation, you can be a lawyer, but you can also be a non-lawyer. And so they've received private equity investment, even though, you know, if you look at them, you just think they're a law firm. And we have reason to believe that, particularly because there's now these two models in major jurisdictions, the UK and Australia, that there's going to continue to be pressure on the ABA and the bar here to consider non-lawyer ownership. And in fact, right now, well, not as we speak, but Canada is considering non-lawyer ownership. And I think we're going to have a speaker later this semester who's going to speak a bit more on kind of the process Canada's going through right now considering this. So when I wrote this paper, I wanted to try to answer three questions. So this whole debate, non-lawyer ownership is going to increase access, but there's been very little actual empirical work that has been done on this. There's been a lot of writing, but it's mostly speculative. It's mostly theoretical. So what kind of empirical evidence do we have that non-lawyer ownership either increases access or doesn't? Second, what is its impact on professionalism? Since this is one of the main reasons people claim we shouldn't have non-lawyer ownership. What has been its impact on professionalism? And then finally, if we think non-lawyer ownership is going to come to the United States, how should we think about regulating it? So first point I want to make is that non-lawyer ownership, and we've seen this very clearly in both UK and Australia, is not some sort of monolithic thing. So we've seen many different kinds of non-lawyer owners. So in Australia, we saw Slater and Gordon, which was the first publicly listed law firm in the world. Slater and Gordon used that capital it was able to raise on the Australian Stock Exchange to expand rapidly within Australia, but also to expand to the UK when the UK market opened up. We've seen venture capital and private equity come into law firms. We've seen big corporations like insurance companies start their own law firms. We've seen consumer ownership. So the cooperative group in the UK, for example, is a consumer-owned cooperative, and they're better known for their grocery store chain, their banking services, their funeral services. But they've, in the last few years, started offering legal services, which they provide not just to their members, but to the public at large. We have seen worker ownership. So law firms are traditionally lawyer-worker owned, but we've seen law firms also giving equity stakes to other people who are part of the firm. So communications directors, technology director, office managers, and being able to give ownership stakes to others within the firm. We have seen government ownership. So in the UK, at the local government level, we've seen local governments spin off their legal departments into law firms that can then provide legal services both to other local governments and to nonprofits for a fee. And I want to emphasize this because who the owners are in each of these different situations can have different impacts on access, what we think their impact is going to be on access, and also raise different sorts of professionalism concerns in each of these contexts. Now, while we have seen many different kinds of ownership forms, we've seen that most investment that has been, we've seen that investment that has gone into the law has gone into different legal sectors at varied rates. So this chart shows by legal sector the market share for different alternative business structures in the UK. So it doesn't show any legal sector where alternative business structures have less than 2% of the market share. So for example, corporate law is not up here because corporate law actually has not seen that much non-lawyer ownership so far for reasons I'm happy to talk about at the end if anybody has questions about that. And you'll notice though, personal injury far and away has seen the greatest amount of investment by alternative business structures. So now this was at the end of 2013 when about a third of the personal injury market was occupied by alternative business structures. That's probably up to 40%, maybe nearing 50% at this point. And we can think of a couple of reasons why this might be. Personal injury tends to have large upfront costs, so there's lots of advertising that has to be done in personal injury. You have to screen claims, most of the claims settle. And it also turns out personal injury is quite lucrative. So when outside capital is thinking about where to invest, personal injury makes a lot of sense. And this brings me to kind of a point that I go through a little more systematically in the paper, and I'm happy to talk about in more detail, which is that, when I looked at access impacts in Australia, in the UK, in the US with these parallels to in online legal services and social security disability representation, I wasn't able to find anywhere that non-lawyer ownership gave a measurable access benefit. Now, I want to provide a caveat here. So there's a couple reasons we might think that this is, and that non-lawyer ownership will give access benefits in the long term. So one is it just might be the kind of data that's available. There's not great quantitative empirical data out there on some of this in both Australia and the UK, although they have better data than the US has, which does an abysmal job at collecting statistics about who needs legal assistance and how the legal market operates in this country. It also might be that non-lawyer ownership is still relatively new, and so that in the longer term, there might be larger access benefits. But I think there's at least 3 reasons to think that the access benefits of non-lawyer ownership might not be as significant as many people think they are. So one is, as I just pointed out, that non-lawyer ownership seems so far to have been attracted to sectors where people already have access. Things like personal injury, where because of contingency fees and because of conditional fees, there's very few people who have a very good claim out there who aren't getting access already in personal injury. Second, as many people in this room know, a lot of people who need access to civil legal services are poor and they have complicated legal problems. And so if I'm a poor person getting evicted from my apartment, it's unlikely that non-lawyer ownership is going to provide me with really any new strategies or new pathways for me to address my problem. And then third, it might turn out that it's just difficult to scale or commoditize certain kinds of legal services. And again, this is something we're going to have to see over time how this plays out. And I think these conclusions are important for the access debate because if it turns out that non-lawyer ownership isn't going to give us the significant access benefits that some people thought it was going to, then we're going to have to turn either to the other regulatory strategies, so loosening unauthorized practice of law, that sort of thing, which might give us some access benefits, or thinking about pro bono or legal aid. There really aren't that many other choices you can pick from. And so although it sounds politically infeasible to a lot of people to, for example, give more money for legal aid, it actually might be the only feasible solution. And if we're thinking about regulatory strategies, we're just barking up the wrong tree. And I think, we can talk more about what legal aid might look like. It doesn't have to be traditional legal aid. And I also think it needs to be legal aid that would be targeted not just at poor people, but also the middle class, because the middle class just can't afford a lot of legal services. And so when I was looking for significant changes in access benefits when I was looking at these three countries. I didn't see any from regulatory changes, but I did see one from this, which is during the same time they brought in non-lawyer ownership in the UK, there was also a dramatic cut to legal aid. And so this shows in private law disputes in the UK, the percent of parties who had legal representation. So you'll see in 2011, about half of parties in private family law disputes in the UK had legal representation. By 2014, the end of the first half of 2014, which are the latest numbers, this is down by about half to about a quarter of parties. You can see where neither party had representation has jumped from about 11% to over 27% now. And so if we're thinking about what's been the access story in the UK and the number of changes that have been hitting the UK legal market in the last few years, it's not non-lawyer ownership, it's this legal aid story. Okay, so if that's the access part of this, what about the professionalism component? So in the paper, I look at conflicts of interest, I look at public spiritedness, so how much legal service providers are willing to engage in pro bono or take on riskier cases that might have a larger social benefit. I look at how non-lawyer ownership might affect standards of professional practice. For now, I'm just going to focus on conflicts of interest. I'm happy to talk about the other two, but conflicts of interest, I think, is a little bit more clear what's at issue, and also has the potential, I think, for having easier regulatory strategies to mitigate against professionalism challenges that might arise out of non-lawyer ownership. So what kinds of conflicts of interest am I talking about? So if you were in the UK, let's say 5 years ago, and you got into a car accident, you would call up your insurance company, and your insurance company, if appropriate, would refer your case to a law firm. The law firm would then contact you and say, do you want to bring a case against the other person that you hit in the accident and their insurance company? For the benefit of this referral, the law firm would then pay the insurance company a referral fee. About the same time non-lawyer ownership was brought in the UK, they also banned referral fees for different reasons. Now, it turns out that referral fees are a lucrative form of revenue for insurance companies. And so to get around this ban, what they did is they started buying up personal injury law firms themselves. So they'd have captured law firms within, and they could refer the cases in-house. No referral fee would have to be paid, but they could profit then from the cases directly that these law firms then did. Now, this sets up the potential for a couple kinds of conflicts of interest. So traditionally in the UK, you have seen, like many markets, the plaintiff personal injury bar is trying to get as much, sorry, where did my water go? The plaintiff personal injury bar is trying to get as much monetary, as much money as they can for their clients in claims. Meanwhile, the insurance industry overall, although they're referring these cases with their right hand, with their left hand, what they're mostly doing is having to pay out claims, right, for their clients. And so they're trying to keep the amount of compensation that's being given out as low as possible. And so when you have law firms, the plaintiff personal injury bar, now captured by the insurance industry, you have a situation in which you have the potential for collusive-like behavior. So for example, in early 2014, a number of the major insurance companies got together and they signed a voluntary code of conduct in which they said that whenever possible, they would bring claims of their clients in these captured law firms to a government and industry-sponsored claims portal, and they would try to keep legal costs as low as possible. Now, this might be in the best interest of some clients, but it also might not be in the best interest of other clients. And when you think of the larger political economy of this as well, it can also change the path of personal injury and tort law in the country. So every 5, 10, 15 years, the UK, like many countries, goes through periodic tort reform. Traditionally, there's lobbyists on both sides, right? There's the plaintiff personal injury bar on one side, and there's there's the insurance industry on the other side. What happens when a good chunk of the plaintiff personal injury bar is now working for insurance companies? I'll put one other kind of conflict that can arise. So the UK also outsourced one of its major legal aid hotlines, which is to a company called Capita. So if you have a legal problem, you will call up this legal aid hotline. They'll refer you to a legal aid provider, social services, or a private attorney. The UK also outsourced to Capita their migrant removal process. So different arms of the company. One arm of the company is doing has the legal aid hotline. The other arm has the migrant removal process. Many people in legal aid are concerned that what happens then is people with questionable immigration statuses don't want to call up the legal aid hotline anymore because there's this fear that the two arms of the company might talk to each other. Okay. So I'm just going to end on this, which is about regulating non-lawyer ownership. So I think, particularly when it comes to conflicts of interest, when conflicts of interest are clear, for example, in the personal injury insurance industry example, then non-lawyer ownership should be banned or at least heavily regulated. But there's a lot of instances where conflict of interest is not so clear, or there's other professionalism concerns you can have. And so there, I think it's up to regulators to decide whether or not to allow non-lawyer ownership. But what's really important, and this is the point I'm going to leave you with, is that it matters who the regulators are. So traditionally in law, we have been concerned about lawyers capturing their own regulation. So for example, when the New York State Bar Association a couple of years ago had a task force on non-lawyer ownership, they looked at it and they said, look, it's a little icky, we have some professionalism concerns, we're just going to reject the thing wholesale. And I think they did so in part, to be honest, because they were also just afraid of outside competition, right? If we're going to be honest about it. Now, on the other hand, if we look at the UK, this is David Clemente, and he wrote a report called the Clemente Report, which was one of the major reports that pushed in non-lawyer ownership in the UK and through the UK Parliament. And in that report, he said, when we think about restrictive practices in legal services like non-lawyer ownership, the burden of proof to keep the restriction is on those trying to justify that burden, right? So pretty much the opposite burden of proof that the New York State Bar Association had. And not surprisingly, he recommended almost wholesale non-lawyer ownership. He also is not a lawyer. He comes from a competition background. He's a Harvard Business School grad, and he was actually the chairman of the board of a major insurance company when he wrote the report. Today, the Legal Services Board, which is the meta-regulator for the different regulatory authorities of legal services in the UK, is run by a man by the name of Richard Moriarty. Richard Moriarty also comes from a competition background, and before joining the LSB, was in charge of regulation at Affinity Water, which is one of these private water supply companies owned by Morgan Stanley. Now, I think different regulators, whether it's members of the bar and the New York State Bar Association, or people like Clemente, they're sincere in their beliefs. I think that they think whatever they're recommending is in the best interest of society. But because they come from very different backgrounds, they come up with very different conclusions about how we should regulate things like non-lawyer ownership. And so I think we have to be worried when there's new capital and new profits that can be being made by outsiders, there's the chance for capture not just by lawyers, but by new outside groups of the regulation of the legal profession. And so I think you need a diverse set of stakeholders when you're thinking about regulation. I think you need members of the bar, I think you need competition advocates, but I also think you need access advocates, you need consumer advocates, you need members of other professions, and you need academics. And I think I'll just say in ending that, I think that there are actually large sectors of the economy that shouldn't operate just on traditional market principles. So healthcare is one, education's one, and law is probably another. But this doesn't mean that we should let law just be captured, have its regulation captured by lawyers, that its regulation should never change. But we need to think about how we shape its regulations in the best interests of society overall. And I think this requires having much more empirical work than we've had so far on what are the implications of different kinds of regulatory changes. So I've talked for long enough, and I'm happy to hear any questions you might have.
Thank you.
So you talked a little bit earlier about the issue of access and that these forms are kind of supplying more access in areas where the need's already met with like personal injury. Mm-hmm. In your research, did you see any like hybrid models, like you would see in maybe the corporate sector having like a nonprofit arm of a corporation or something like that?
So maybe not a nonprofit arm of corporation. So one that I mentioned just in passing, which I think is a really interesting example, and I didn't talk about it in as much detail, is the cooperative group. So cooperative legal services, which essentially operates like a nonprofit in some ways because it's consumer owned, like many cooperatives do. And when you talk to the folks at cooperative legal services, they say, look, the cooperative has this larger social mission in UK society more generally. And so we don't need to turn a profit right away. We don't even maybe necessarily have to turn a profit at all. A lot of people, when legal aid cuts happened in the UK, a lot of people who were in that sector went over to the cooperative thinking, okay, this sector is getting cut, but maybe we can make a difference with this kind of more market-oriented alternative business structure strategy over in the cooperative. They're now the largest provider of family legal aid in the UK, so they've got a bunch of family legal aid contracts around the UK. It's in the paper, but it's like 70 or some of them. So of them, they have fixed pricing on family legal on family law services, so divorces, that sort of thing. And they're often pointed to as a model of how alternative business structures and non-lawyer ownership can lead to a bit more of a hybrid model. Unfortunately, and this is a problem with both cooperative legal services and the cooperative group, they've been having financial trouble. So the larger group got really hit during the financial crisis, and they had some problems with their banking arm. And the legal services component has never made a profit. And so it's just unclear if they're going to be able to scale in such a way that they find that it's profitable. I think they, unlike other for-profit businesses, can keep that going for longer, but I find it unlikely that they will keep subsidizing the legal services arm if the legal services arm can't start generating a profit initially.
So there is already a discussion about the quality of lawyering in the public interest sector. Did your paper talk about how to measure quality of non-lawyering ownership, and how do you think that would impact, the already legal service legal impact in the public service sector already? Like, how do you think that would impact?
It's a good question, and it's something I've grappled with a little. There's a couple issues or challenges with trying to answer that question. So one is trying to measure quality in the first place is notoriously difficult. You can do this a bit off consumer complaints. So for example, in the UK, alternative business structures, there's been slightly more complaints about them than traditional law firms. It's unclear why this is. It might be because a number of them are also like new businesses that are just starting up. They've also been a little bit better at addressing the complaints than traditional law firms. So these are complaints going into the ombudsman, but that's only one way to measure quality, obviously. In the US, there's a thought that if we bring in non-lawyer ownership, so if we bring in something like Walmart to help start providing legal services, Walmart worries about its reputation overall. So theoretically, the idea is if Walmart started offering legal services, they'd want at least a floor level of quality that they'd want to be able to guarantee. That's one idea. Another idea that we can see from examples that has actually happened in the US is Binder and Binder. So Binder and Binder is in Social Security disability representation. There's a lot of problems with quality of lawyers in Social Security disability representation. Binder and Binder never had a great reputation. After it got non-lawyer investment, my understanding it still doesn't have a very good reputation, but they have a model. They just churn it, right? They have a bigger chunk of the Social Security disability representation market than anybody else. They're the largest player out there, and they just have volume that they can go through. And so one idea is maybe they can take on cases other people wouldn't be as likely to. The other side of that, though, is, and it's hard, you get very conflicting reports and there's no good empirical data, but when you talk to people, it all depends on kind of who you talk to. The other idea is they take on so many cases that they're okay if some don't really work out and slip through the cracks, because it's all about volume for them at the end of the day. So I think it's going to really be context specific on who gets into legal services. So I think if Cooperative gets into the legal services in the UK, they're going to really try to maintain a high level of quality. If Binder gets, I guess this is going on YouTube, but I'm no slander towards Binder. But if Binder gets into, has outside investment, it's unclear if it's really going to help improve quality. Yeah.
I think this is really maybe a regulation issue, whereby, for instance, you have insurance retainership with the same company that is also handling maybe a personal injury case. How do you bring in what needs to be done to protect clients' interests? Because it's possible to share information, and you don't want that information, for instance, to be shared.
Right.
Because it might undermine the effectiveness of your case. So if the same non-lawyer institutions are handling different components of your case, and you, for one reason or the other, because you also need to protect yourself, you don't want that information to mix. There is actually no way of ensuring that doesn't happen.
Right. Yeah, no, and so I think this is a problem. I mean, one of the things that I'm tempted to say, but I won't go that far, is, maybe we should think about just banning companies from providing legal services that also provide other services. So that would be one strategy you could go about that. That might be too broad of a rule, but at least it would be a safe rule, right? Because you wouldn't run into this situation where different arms might talk to each other. So I know, for example, the Cooperative has thought about this a lot and tried to put a lot of measures in place. So their financial arm isn't talking to their legal services arm and sharing confidential information. This has been an issue that's been highlighted. So one company I didn't talk about in this presentation that's gotten a lot of press, not always good press in the UK, is a company called Quindel. So what Quindel does is they're also in the personal injury space, but they're not an insurance company. They have a slightly different, interesting strategy. So what they've done is they've contracted with the insurance companies to be the first point of contact when you call after, say, an auto accident. So they're the one on the other end of the phone, right? So they pick up the phone and they say, okay, you've been in an accident. We're alerting your insurance company now. Somebody's going to go out. They're going to see about your claim. But also, we're going to talk to you and say, do you need auto repair services? Do you need car rental? And hey, do you need legal services? And so they get around the referral fee ban that way. But the reason there's been some criticism about Quindel is they also have another arm where they have a group of medical experts. And so what they'll do is they'll send you to their doctors, right? Which they literally own in a different arm of the company. And then diagnose, well, do you have back pain? Do you have, have you had trauma to your neck? That sort of thing. And so, they've come under criticism, particularly by the bar in the UK, of, is there enough barrier? Quindel claims they've set up systems and their doctors are independent and that sort of thing. But there's already, anybody who knows the personal injury space in the US or in the UK knows this is already a problem, right? That lawyers have relationships, personal injury lawyers have relationships with doctors that they send clients to, but at least they're literally not part of the same enterprise, right? So are we just kind of giving in at this point? So I think your point is quite valid, and it's something that we're going to have to see how it develops in the UK. In Australia, for whatever reason, we haven't seen as much of these kinds of more complicated models. I think because the Australian market is much smaller than the UK, there's not as much capital. We've seen a few prominent law firms list on the stock exchange, but not nearly as much of these kind of experimenting with different forms, which sometimes might lead to a better product for the client or the consumer, but also can lead into these conflicts.
What explains the fact that lawyers have been allowed to self-regulate in a way that other service industries haven't? For example, financial services. Like, I've never heard of a law firm merger being blocked because of antitrust concerns, for example.
Right. Although, yeah, so part of the reason law firms aren't blocked because of antitrust concerns is because the legal market is just like highly fragmented. And actually, it's interesting when you look, this is just a bit of an aside and I'll get back to the question, but in the UK, the regulators there have this idea that the legal market is not consolidated enough, right? And so they're trying to take measures to consolidate, including things like when giving legal aid contracts out, only giving it to firms over a certain size, because they think that if firms are too small and too fragmented, you just don't get the economies of scale. So that's part of the reason you haven't seen any sort of, I think, antitrust activity in the US is it's a really fragmented market. Now, why lawyers have traditionally self-regulated, David would probably be in a better position to answer, but I'll just say, that it comes out of tradition. So a lot of the professions have self-regulated. And what's interesting in legal services is we shouldn't think about it and the legal profession and changes in regulation in the legal profession in isolation. We've seen a much larger movement across different professions. So when you think about medicine, right, is another place where doctors have self-regulated for years. Who can become a doctor? How many medical schools can open? Accountants for the longest time self-regulated, and the federal government had to step in after Enron, essentially, and accountants are not self-regulated in the same way that they used to be. Engineers, architects, they set the standards, they set the tests. But what you see is both in the UK, Australia, also in the US to a lesser extent, the Federal Trade Commission stepping in. And so the FTC has stepped in and said to lawyers, there used to be bans on advertising, for example, and said you can't ban advertising. There used to be fixed fee schedules for what lawyers could charge and say, look, you can't set rates in the market. You're acting like a cartel. And so what I think we're seeing in all of these professions and in all these occupations is a movement from a much more of a, not exactly a cartel, I would say, more of an old, what's the word I'm looking for?
Guild.
Thank you, guild. Kind of a guild-like system to a much more kind of public governance system, but we're somewhere in between, right? So we're still kind of half guild, part public governance, and we're not quite sure what kind of public governance to put on the system, because we still know, there was just this Supreme Court case in the US about teeth whiteners. The teeth whitening case, I don't know if anybody of you have been following this, where this is a dental case, right? So the dentists in North Carolina went after the teeth whiteners in shopping malls because they said, look, you're cleaning teeth, right? And they tried to shut them down. The FTC said, no, you're stepping outside of your mandate. Now, I won't get into the details of the case, but during oral arguments, you have, Scalia and Kennedy there, and they're having this argument about, we think this is cartel-like behavior by the dentists or by lawyers or by doctors. But then again, we don't want some government bureaucrat deciding who gets to be a neurosurgeon or not, right? Because we rely on expertise from each of the professions to self-regulate in a way, because it's just very expensive to figure out, how many years should law school be, what should be on the test for the bar, all these sorts of things. So the government's position has always been just hand this off, right? And now we're seeing much more of kind of, I think, a public governance type move. But that's my short answer.
One of the big limits to access is especially in certain areas of law where there's very little chance of revenue. So for example, say criminal defense, indigent, or family law, where you have maybe two indigent people, fighting over a marriage gone awry or fighting over custody. There's simply no means for revenue like there is from, either suing for discrimination where there's some sort of damages. There is some sort of money being exchanged. So is there any way that this alternative structure can help that beyond simply, if say Walmart does set up Walmart,
Yeah.
and I can go in and I can, for $10, I can hire Walmart to defend me in my DUI. So beyond simply dramatically lowering costs because of efficiencies and scale and things like that, is there any way to sort of square that circle that's due to sort of lack of revenue?
Yeah, no, that's an interesting question. So, and that you mentioned it, it's timely, because you brought up criminal law, and this obviously was all about civil legal services, but there's just a recent development in the UK legal market where for the longest time, there wasn't non-lawyer ownership, outside investment going into criminal law for some of the reasons you were saying. It also tends to be very kind of attorney specific, especially high-end criminal law. You want your Johnny Cochran or whatever, and he's going to make all the money. But there was this nascent idea when there was this shift in regulation around non-lawyer ownership in the UK that if we could drive down prices through non-lawyer ownership, then our legal aid dollar could go farther. And so we just saw a major criminal law firm in the UK take private equity, or maybe it was venture capital. I think it was private equity. And they're also one of the major criminal legal aid providers in the UK. And so they get contracts, right, from the UK government to provide criminal legal defense. I haven't thought through completely all the types of conflicts of interest and that type of thing that can arise once you start bringing outside investment into criminal law. I think it's something that has to be thought about very closely, and the stakes are even higher than in the civil law field. But this was the hope by some regulators in the UK who saw competition as the answer, that, look, we're cutting the legal aid budget, both criminal and civil, but maybe these dollars can go farther because we're going to have these new business structures, right? And so we'll see how this plays out. But I think you're right that the reason it goes into personal injury, the reason it goes into certain sectors is there's deep pockets. And, we'll see. We'll see if Walmart can figure something out, or the equivalent in the UK, where they can provide these services at a cheaper price. But I think yours is the big question. And so far, I haven't seen it, right? That's kind of the conclusion from the paper. But that doesn't mean it's not going to happen, and that doesn't mean the market's still not moving.
Has there been any pricing data looked at in terms of either in Australia or the UK in terms of whether or not these economies of scale are actually
super interesting? Yeah, I was surprised about this because I always thought the West always did a better job of keeping track of things, but we don't. The US is horrible on pricing data. As far as I can tell, we'll never know how much a divorce cost in 1986, and so we'll never be able to price that back because we've just never collected that. The UK and Australia are in similar boats, but the UK has started collecting this. So they've only done time 1 or time 0 a year or two ago around certain common things like divorces, like writing wills, certain basic legal services that people have, randomly picking in different parts of the country and different types of legal providers. But because we don't have robust data, we really don't know. And as you know, you can't really go off advertised prices. Although fixed rates are becoming more common, that's not even always what people end up getting charged. So it's very difficult to see. There's been some surveys in the UK done on just consumer satisfaction levels, and if they think they're getting more value for money. There's some indication that people do think they're now getting some more value for money. It's also unclear if that's becoming because of non-lawyer ownership. It also might be because there's been these dramatic cuts in legal aid. And so that means a lot of attorneys are just charging less because there's more pressure on the market overall. So I wish there was a better answer. Yeah. There and then there. Yeah.
To the conflict of interest in relation to litigation.
Mm-hmm.
My understanding of the UK legal law specifically is that it's other barristers and solicitors.
Yeah.
The barristers are those who actually manage litigation and are independent from the law firms. So So would that actually act as a gatekeeper or a bar against possibly pressuring
Oh, between the solicitors and the barrister barrier. It might, except for the problem is most of these cases settle on the personal injury cases. So it's not necessarily, very few of these actually make it to court. There's a threat of going to court. There's talk about going to court. There's a lot of like, I'm going to go to court if you don't do X, Y, or Z, but there's very little actual going to court. But you bring up an interesting point that the UK not only has a separation between solicitors and barristers, they actually have there's 7 or 9 different legal service categories. So they have solicitors, so barristers who argue in court, solicitors who kind of do the other writing lawyering, but they also have notaries, which are much more empowered than notaries here. They have people who do intellectual property, they have conveyancers, so people who do a conveyancing course, and then they can transfer property. And they did this in part to help bring down prices. And there is some evidence that shows, for example, around conveyancing, that having conveyancers who don't require as much education as a full solicitor or barrister does bring down the price of conveyancing for just kind of typical real estate transactions. But again, there's not as many good studies as you might imagine on these things, and the numbers are a little flimsy when you get into them. Yeah.
Yeah, so I'm kind of interested in how the perspective of the people who enter different industries kind of influences how well or unwell they serve the disadvantaged population, right? So when you think of education, most people know that people don't become teachers to become wealthy, right? They become because they passionately believe in education. And when you look at the people who self-select into Wall Street, it tends to be a very different kind of person who kind of, it's fairly evident why self-regulation doesn't work in the finance industry, just because of who self-selects in and out. The legal industry is interesting because I think, I do believe a lot of people enter the legal industry in a well-meaning way, but at the same time, the entire profession is built around billable hours, and I don't think you have to be a lawyer for very long before every minute just is equated to dollars and cents, and that puts pressure on trying to do some of this other stuff. And pro bono helps, but actually that's tends to be going down over time, not up in a lot of ways. And so when you look at the medical field, which is another area where you have a big unmet need, you kind of have a division between the doctors who enter it well-meaning, just like in a lot of ways doctors and lawyers are equivalent, but you have this big nursing population where they don't go into it for money, right? I mean, nurses are more similar to educators. So it's maybe part of the solution may be who you allow. It is who you allow to provide these kinds of services. And right now the UK model is built around, how do we get these companies who know how to take advantage of big numbers and kind of get this operating leverage so they still get wealthy and just in a different way, right? But that's still a very different model from like nursing provided health services to disadvantaged populations, or teachers providing services to disadvantaged kids and other people who need education. So is there maybe a third model that we're not looking at?
The third way, yeah. This is good. This is something that I struggle with a lot, thinking about, in that, as you point out, we don't judge doctors by, at least most of us don't, by, which one makes the most money, but, do they produce health outcomes? We don't judge teachers by which teacher makes the most money, but who's the best teacher, researcher, or whatever it is. But there's these other reasons that people get into certain professions, and law is, as you point out, this. As soon as you point that out, there's always somebody who will point out, but law firms are just as greedy or more greedy than the most ruthless Wall Street company that's out there. And that's true of some law firms, but there's a good chunk of law firms who aren't. There's different law firms that take different paths. And one of the concerns, and we see this playing out in Australia a bit, I profile Morris Blackburn and Slater and Gordon and Shine lawyers, and both Slater and Shine, these are the 3 largest personal injury law firms in Australia, but they're increasingly becoming just the 3 largest consumer-oriented law firms in Australia, as the market really is consolidating there. And if you talk to people at Morris Blackburn, they come from a labor law tradition, right? And so there's a certain reason their lawyers get into the game. And they've said publicly they're going to resist going on the stock exchange as long as they can, even though Slater has and because Shine has, because they think if they go on the stock exchange, they then have to respond to the market, right? There's going to be expectations to meet, end of the year revenues, whatever it is, and so that's going to compromise the kinds of social justice cases they can take on, the pro bono cases they can take on. Then again, you have, not to pick on them, but firms like Binder, right? Which was a law firm before it took private equity, and no one ever really thought they were doing, great social work and all that. I mean, they are in that they're helping people, but that wasn't typically why people would join Binder and Binder. I think people joined Binder and Binder in part because they couldn't get jobs in other places. So you would join, but they. So yes, I do think. How do we reconcile this, right? And we can think of different kinds of capital too, because I like to contrast like New York Wall Street companies, bankers, finance, where you think it's all about the money. And then you think about, and I think this is partly part of the reason, non-lawyer ownership has been seen as a much more popular idea I've noticed in the US on the West Coast, in Silicon Valley, in part because of the beliefs of what technology can do and the requirements of outside capital for technology to provide legal services in a certain way. But I also think because the experience with large corporations has been very different in Silicon Valley, where you have your Apples and your Googles, and they're just making so much money that we're off to save the world and do all these other things as well. And they view themselves as having a social-minded mission as well. And these are companies that are both regulated in exactly the same way, whether you're a bank on Wall Street or whether you're Apple or Google or whatever it is. But you can have very different orientations for how you're going to make a difference in the world, or what you think the aim of this whole enterprise is. But I do think it makes sense to think about, what are potential third ways. So things that have been proposed, I don't know how they'd work out. You could require, for example, legal services companies to be benefit corporations, where they have to have a stated public interest mission, which the way benefit corporations work in the US, it's very hard to enforce that mission, but it would at least allow them to take on a public interest mission without any fear of getting sued by their shareholders or anything like that for not trying to maximize profits. I think you could encourage things like consumer ownership or certain kinds of owners that we think might be more public-spirited minded.
Yeah, I guess part of my
Am I not answering the
ownership may not be, there's ownership isn't the only dimension, right? I mean, ownership is just actually changing one elite class for a different elite class. It's not really solving the problem in lots of ways. And if you think about, again, nurses and teachers, I think are really good examples of a whole group of self-regulated profession. They have a very different outlook than doctors and lawyers and Wall Street people.
I see what you're saying. So how do you bring up?
So the Wall Street people, you're actually talking about Wall Street people who are the ones who are kind of organizing these things, or the
right, because so far they are, yeah.
The venture capitalists, it's a finance play ultimately at its heart.
Yeah.
And I'm still, like you said, I'm still not convinced that solves any problem, because you're just replacing one elite class with a different elite class.
Right.
It's not really solving the access issue. It seems like maybe the access issue is more about who is allowed to provide those types of services, and it's not about scale so much as just a different outlook in a profession, right?
No, and I think, I get that point, and I do think, the problem that we've always wrestled with is like, how do you, where is money coming from for this? Like, the reason we track ownership is because profits incentivize people, unless, for example, we went to, and this has been suggested in Canada, of a much more public legal service system, right? Where everyone has a right to certain legal services. And they're provided by the government, and then the government can provide those through a series of different kinds of practitioners that might be lawyers sometimes, might be paralegals, might be, different kinds of people who would be being paid, a reasonable wage, but not that much. And so if you're going to go into that, you're probably going to go into that for a certain set of reasons. But if you're not going through government funding, I think it is hard to figure out how you sustain the model.
But
right?
education, see, that's the thing, is money motivates people if you only think in a narrow dimension.
But education, for example, is government. I mean, I think the teachers you're mostly talking about are...
Education tends to be government, but there's an enormous amount of non-government
Right.
education-related services that, again, they're not in it for the money. Certainly the nurses, a lot of non-government ownership of the healthcare system, and most of those people that enter those professions are just not, money is not the primary motivator.
Yeah.
So
how do we maximize that?
Right,
Yeah.
if we have this myopic thinking that we have to align monetary incentives with the goal, then we really limit the options available to us.
Yeah.
When we start to realize that actually there's proven motivators that are much more powerful than money in certain sectors, but people self-select and self-select out, right?
Yeah.
How do you engage
Those people.
Those people.
Yeah. No.
Because this doesn't do it.
Yeah, no, I think non-lawyer ownership in a lot of situations doesn't. Yeah.
Right.
No, that makes sense.
Yeah.
Thanks. I know we're right. I know we have to give the room up, so but I'm happy to talk to anybody more after.